She built a padlocked steel gate across a gravel road that my grandfather's boots had worn smooth for 43 years. I pulled up that Tuesday morning in August, the truck loaded with harvest bins, the Vineyard crew behind me, and there it was. A galvanized gate, chain-wrapped, branded with a laminated HOA notice in a Ziploc bag. Private road. No access. BY order of Cedarbrook Heights Homeowners Association. Standing next to it, arms folded, phone raised to record me. Judith Creel, president. The woman who had moved into this neighborhood 14 months ago and had been systematically dismantling every right I had left. What Judith did not know, what she could not have known, because she never bothered to check, was that the road was not the HOA's to close. It was mine. Recorded. Deeded. Ironclad. And the strip of land her brand new gate was sitting on, that was mine too. I am a third-generation wine grower, a property rights attorney by training, and I had been waiting for exactly this moment. Stay with me. Because by October, Judith's HOA was writing me a check every single month. My name is Wade Harlan. I am not a hobbyist. I am not a weekend farmer who bought a pretty piece of land to impress people at dinner parties. I am a third-generation winemaker running Harlan Ridge Vineyard, 1,110 acres of Pinot Noir and Chardonnay in the foothills of Oregon's Willamette Valley, on land my grandfather Emil bought when this county was still mostly timber and fog. I also spent 11 years practicing property law in Portland before I came home to run this place. I did not leave the law behind when I traded the office for the vineyard. I brought it with me. Every deed I have ever signed, I read first. Every easement on this property, I know by heart. Every boundary line, every recorded instrument, every tax parcel, I know them the way my grandfather knew his vines. Which row, which block, which slope faces southwest and holds heat past sundown. That background matters. Because what happened to me in the summer of 2023 was the kind of thing that destroys family farms. Not drought, not disease, not a bad vintage. A woman with a padlock and a title and absolute certainty that she was right. Harlan Ridge has been in continuous operation since 1961. My grandfather Emil planted the first 2 acres of Pinot Noir by hand, just him, a borrowed tractor, and a soil map he would study for 3 years before he ever broke ground. He was 41 years old, an immigrant from County Cork who had spent his first years in Oregon working logging camps to save enough money to buy land that nobody else wanted. Too steep, they said. Too isolated. Too hard. Emil did not argue. He just planted. By the time my father Frank inherited the vineyard in 1987, it was 85 acres and had won 3 gold medals at the Oregon State Fair. By the time Frank died of a heart attack in 2008, too young, 58 years old. Standing in the South Block on a Tuesday morning in October, it was 1110 acres, a tasting room, and a mailing list of 4,000 people who ordered every vintage we produced. I drove home from Portland for the funeral and never really went back. The vineyard needed running. And somewhere in the back of my mind, I think I understood that this was always where I was supposed to be. What I did not understand, not yet, was that the fight for this land was not over. It was just about to begin. Late July in the Willamette Valley has a particular quality that is hard to describe to someone who has not stood in it. The fog burns off by 9 in the morning, and what is left is this clean, cool light that falls through the vine canopy in long, flat angles. The clusters are heavy by then, dark and tight on the Pinot Noir, pale gold on the Chardonnay, and the whole vineyard smells of warm soil and crushed leaf and something faintly mineral that I have never been able to name but have known since I was 4 years old. I was walking the South Block that morning, the oldest block on the property. Emil's original planting from 1961, the vines are over 60 years old now, gnarled and low to the ground. The kind of ancient root system that goes 6 feet deep and pulls flavor out of the volcanic basalt below like it has been doing it forever. Because it has. Emil Harlan arrived in Oregon from County Cork, Ireland in 1954 with $30, a single suitcase, and a letter of introduction to a logging camp foreman outside of McMinnville. He worked that camp for 4 years. Saved every dollar he did not spend on food. Learned English from a King James Bible and a road atlas. And in 1958, he bought this land, 110 acres that every other buyer had passed on because it was too steep for row crops and too far from town to be a practical homestead. What they saw as a liability, Emil saw as a vineyard. He spent 3 years studying the soil before he planted a single vine. He hired a lawyer, a proper one, not a friend, not a neighbor for every transaction. The purchase deed, the water rights agreement, the timber easement negotiation with the logging company on the adjacent parcel. Every document recorded at the county courthouse. Every receipt kept in a fireproof box under the farmhouse stairs. That box is still there. I know because I have opened it. The gravel access road that runs along the western boundary of this property was established by Emil in 1958 as part of that original timber easement negotiation. Not a right-of-way, not a courtesy. A fee-simple ownership strip 14 feet wide, 340 feet long, recorded as a standalone parcel, tax-assessed, permanent. Emil built that road so nothing could ever stop us from getting our fruit out. He was right about almost everything. For the first 46 years of its existence, Harlan Ridge had one neighbor on the western side, a timber company that ran selective cuts every 8 to 10 years and otherwise left the land alone. Quiet. Predictable. The kind of neighbor a vineyard needs. That changed in 2004. The timber company sold their adjacent 30 acres to a residential developer out of Portland. Cedarbrook Heights, they called it. 48 homes, planned community, mandatory HOA. The construction ran 18 months and was exactly as disruptive as you would expect: heavy equipment, grading, the constant backing beep of dump trucks starting at 7 in the morning. I was still in Portland at the time. My father Frank managed it with the same patience he managed everything. He introduced himself to the developer's project manager on the first day of grading. He explained the access road, its history, its legal status. The project manager nodded, made a note, moved on. The developer's attorney, to his credit, did his job correctly. The Cedarbrook Heights plat filing recorded at the Yamhill County Courthouse in 2004 acknowledges the Harlan easement in Exhibit C, page 14. 4 sentences. Dry legal language. Easy to miss if you were not looking for it. Easy to forget if you would never read it in the first place. The first HOA board was chaired by a man named Gerald Foss, a retired Yamhill County commissioner who had lived in this valley his entire life. Gerald understood the difference between a rural property easement and a suburban homeowners association. He and my father had coffee twice a year. There were no issues. Gerald aged off the board in 2014. The residents who replaced him were newer, younger, less rooted in the history of the land. By 2020, the board was run entirely by people who had moved here from Portland and Salem and Bend, people who loved the idea of living next to a vineyard without fully reckoning with what a working vineyard actually requires. Trucks, early mornings, gravel roads, dust. That was the kindling. Judith Creel was the match. Judith Creel moved into Cedarbrook Heights in September of 2022, house number 7 on Ridgeline Court, the one closest to the access road, with a kitchen window that faced directly west toward the vineyard. I noticed the moving truck the way you notice any new neighbor in a small community. Noted it. Moved on. She ran for HOA president 2 months later, won by 3 votes. Nobody else wanted the job. Her first act as president was a letter, certified mail, HOA letterhead, sent to every adjacent property owner in the area, including me, informing us of the board's commitment to maintaining community aesthetic standards and protecting residential quality of life. It was the kind of letter that sounds reasonable until you read it twice and realize it does not actually mean anything. I filed it. Her second act involved me directly. November 2022. A noise complaint filed with Yamhill County, citing commercial vehicle activity at unreasonable hours on the access road. The county investigated. The road is classified as an agricultural access route. The hours of operation: harvest typically runs 5:30 in the morning until early afternoon, fall within the lawful parameters for agricultural activity. Complaint dismissed. I received a copy of the dismissal in the mail and did not think much of it. December 2022. A certified letter from the HOA requesting that I voluntarily pave the access road at my expense to reduce particulate matter affecting residential air quality. I responded with a single certified letter of my own, polite. 2 paragraphs. The road is private property. Paving decisions are mine alone. No further response required. That was the moment it became personal for Judith. I did not know that then. I learned it later from Hugh Tanner, the former board president, who had watched the whole thing from his front porch and understood exactly what was happening. He told me afterward that Judith had read my response letter at the December board meeting, out loud, to the assembled members, and then set it down on the table and said, "He thinks he can just ignore us." That sentence told me everything I eventually needed to know about Judith Creel. She did not want the dust resolved. She did not want the noise reduced. She wanted acknowledgement. Deference. The particular satisfaction of a person who has spent a career managing other people's compliance and has just discovered that one person on the edge of her jurisdiction is not complying. Over the next 14 months, she filed 2 more county complaints, organized a neighborhood safety committee, installed a speed bump on an internal HOA road my drivers occasionally used as a courtesy cut-through, and demanded a $4,800 annual road maintenance fee in writing. Every single action went nowhere, which only made her angrier. The call came at 6:15 on a Tuesday morning in August. Rosa Infante, my vineyard manager of 22 years, a woman who has seen every kind of harvest problem there is: frost in September, smoke taint from a wildfire 3 counties over, a forklift with a blown hydraulic line on the first day of picking, and who does not call me before 7 in the morning unless something is genuinely wrong. Wade. Her voice was flat. The road is blocked. I was dressed and in my truck in 4 minutes. The gate was exactly what Rosa had described, and somehow worse in person. Galvanized steel. 2 posts set in fresh concrete, the kind that had been poured recently enough that the edges were still sharp. A heavy chain, padlocked, wrapped twice around the center bar, and zip-tied to the chain, in a Ziploc bag to protect it from the morning dew, a laminated notice on HOA letterhead, BY order of the Cedarbrook Heights Homeowners Association Board of Directors. This road has been designated a Controlled Access Community Corridor under the 2023 Community Access and Infrastructure Amendment. All non-residential commercial vehicle use requires prior written approval from the HOA board and payment of the infrastructure maintenance levy. Unauthorized access will result in removal of vehicles at owner's expense. Signed at the bottom, in blue ink. Judith Creel, President. She was standing 15 feet away when I finished reading it. Arms folded. Phone raised, camera facing me. She was wearing a cream-colored jacket over a dark top. Her hair neat, her expression the careful neutral of someone who has rehearsed this moment. She looked, I remember thinking, like a person conducting a performance review. Mr. Harlan. Her voice was measured, almost pleasant. The board voted on this at our August meeting. You will need to submit an access application and pay the infrastructure maintenance levy before we can grant permission for commercial vehicle use. I can have the application form emailed to you this morning. I looked at her for a long moment. Judith. I kept my voice even. I'm going to give you one opportunity to remove that gate today. Something shifted behind her eyes. Not quite surprise. More like recalibration. Is that a threat? I am recording this, just so you know. It is not a threat. It is a courtesy. Same kind of courtesy I have been extending for 14 months. She did not respond, just held the phone steady. I got back in my truck and drove home. I want to be clear about what I was feeling in that moment, because it was not what you might expect. It was not rage. It was not panic. Harvest was 6 weeks out. Without that road, I could not get the bins, the forklift, or the refrigerated transport trucks to the back blocks. I was looking at somewhere north of $280,000 in fruit that would either be picked on schedule or lost. The alternative route, the public county road on the east side, added 40 minutes per load, crossed a weight-restricted bridge that the transport trucks could not legally use, and would push my labor costs past any margin I had left. She had not just blocked a road. She had aimed a gun at a year's work and 60 years of family history. But I was not panicking. I was thinking. I drove home, went to my office, opened my laptop, and pulled up the Yamhill County Assessor's GIS parcel map. I had looked at this map dozens of times over the years. I knew every boundary line on this property. But I wanted to look at one specific thing with fresh eyes. The gate was new. The concrete was fresh. Judith had put it up within the last 48 hours, which meant she would have had it planned and contracted for longer than that. I zoomed in on the western boundary, the access road. The 14-foot strip Emile had recorded in 1958 as a standalone parcel, parcel 47C on the county map, assessed separately, taxed separately, owned by Harlan Ridge Vineyard LLC without interruption since the day Emile filed the deed. The gate was sitting on parcel 47C, not on HOA property, not on the easement corridor, on a parcel I owned outright, in fee simple, with 65 years of continuous tax payments as evidence of that ownership. Judith had built a permanent structure, posts set in concrete, chain, padlock on land that belonged to me. Without my permission. Without a permit. Without so much as checking whose name was on the tax assessment. I sat back in my chair. Outside the window, the south block was catching the morning light. The old Emile vines, dark green and heavy with another year's fruit. I opened a blank document and started typing. She handed me everything I needed, I wrote at the top of the page. And she had no idea. I spent that evening at my desk with every document spread across the table in front of me. The 1958 deed, Emile's original purchase, handwritten in the old meets and bounds language, the kind of precise geographic description that takes a trained eye to read but leaves absolutely no room for interpretation. The timber easement agreement from the same year, signed by Emile and the logging company's general manager, notarized, recorded. The 2004 Cedarbrook Heights plat filing, all 47 pages of it, including Exhibit C, page 14, where the developer's attorney had done his job and quietly acknowledged the Harlan easement in 4 dry, easily overlooked sentences. My own title insurance policy. And finally, the document I would requested from the county recorder 2 weeks earlier when I first sensed this was escalating, the HOA's full CC&Rs, their governing document, the legal foundation for everything Judith claimed she had the authority to do. I read the CC&Rs twice. Section 4. 7. Buried on page 19, between a clause about satellite dish placement and one about approved exterior paint colors. 11 sentences. The developer's attorney, to his credit, had been careful here too. Nothing in this declaration shall be construed to limit, restrict, or supersede any pre-existing recorded easement or right-of-way benefiting adjacent properties. The HOA's own governing document said they could not do what Judith had just done. I kept reading. I pulled up the 2023 Community Access and Infrastructure Amendment, the document Judith had cited on her gate notice as her authority. It had been passed at an August board meeting. 11 of 48 members present. Oregon Revised Statutes Chapter 94, which governs planned communities in this state, requires a quorum for any valid board action, and for amendments affecting property access rights, a supermajority of the full membership. 11 of 48 was not a quorum. It was not even close. The amendment was procedurally void, unenforceable on its face, a legal nullity dressed up in HOA letterhead and blue ink. I closed the laptop. I had a trespass claim, a private nuisance claim, a declaratory judgment action to void the amendment, and something else, something I had not fully played yet, something I would noticed in the parcel map that I was not ready to move on, not yet. Judith interpreted my silence as weakness. I understand why. She had built a gate, signed her name to it, delivered it in writing, and the person on the other end had driven away without a word. In her world, the world of HR departments and compliance matrices and people who back down when institutional authority is invoked, that silence meant she had won the first round, that the next step was negotiation on her terms. So she escalated. Within 2 weeks of the gate going up, she had filed a complaint with Yamhill County Planning claiming the access road constituted an unpermitted commercial haul route requiring a new conditional use permit. She contacted the Oregon Liquor and Cannabis Commission, which also licenses wineries, with a vague written complaint about unlicensed commercial activity adjacent to a residential zone. She submitted a noise and particulate matter complaint to the Oregon Department of Environmental Quality, citing dust from the gravel road as a potential air quality violation. Each complaint was filed on HOA letterhead, each one signed by Judith Creel, President. The County Planning Department dismissed her complaint in 48 hours. The road had been in continuous classified agricultural use since 1958. No permit required. No violation found. The OLCC called me directly, slightly apologetic in tone. They closed the complaint with a form letter that same week. The DEQ sent an inspector. He spent 2 hours at the property, took particulate readings at 3 points along the road, compared them against Oregon agricultural standards, and found nothing actionable. On his way out, he stopped to talk to Rosa Infante for a few minutes. Rosa told me later what he said. "I have seen this pattern before. Someone's decided to make your life difficult. You are doing everything right." 3 complaints. 3 dismissals. 3 weeks. But then came the letter to my distributor. Hendricks & Cole, a Portland-based wine importer I would worked with for 12 years, called me on a Thursday afternoon. Their tone was careful, measured. They were not pulling out, they said. But they had received a letter from the Cedarbrook Heights HOA implying that Harlan Ridge was operating under an active regulatory dispute and suggesting they may wish to consider the reputational implications of their continued business relationship with the winery. I asked them to send me a copy. They did. I read it once, set it down, added it to the folder. Judith had just made her most consequential mistake. 3 weeks before harvest, I was at my desk again, reading the 1958 deed for the third time that week. Not because I had missed something. I had not missed anything. I was reading it the way you read a document, when you know the answer is in there somewhere, and you want to make sure you are seeing it completely, every word, every clause, every old-fashioned legal phrase that Emil's attorney had chosen with deliberate care 65 years ago. And then I saw it. Not something new, something I had always known but never fully processed. Never needed to process until now. The access road strip was not an easement. An easement is a right, a legal permission to use someone else's land for a specific purpose. Easements can be challenged, modified, occasionally extinguished under the right circumstances. They are strong, but they are not the same as ownership. What Emil had negotiated in 1958 was not an easement. It was a conveyance. The timber company had transferred the 14-foot strip to Emil outright, fee simple, unconditional, permanent. Emil did not have the right to use the road. Emil owned the road. The strip of land beneath it, the gravel on top of it, the airspace above it. His, completely. When the timber company sold their remaining acreage to the Cedarbrook Heights developer in 2004, the 14-foot strip was explicitly excluded from the sale. The developer built the subdivision around it. The HOA managed the surrounding roads. But Parcel 47C, that narrow corridor, 340 feet long, remained exactly what it had always been. Harlan Ridge Vineyard LLC. Owner of record. Tax assessed. Current. I called my title insurance company that afternoon. Confirmed every detail. Parcel 47C was in their coverage. Clean title. No liens. No competing claims. No encumbrances of any kind. Taxes paid without interruption since 1958. I set the phone down and walked outside. It was late afternoon, the light going gold across the south block, the old Emil vines throwing long shadows down the slope. I stood at the top of the hill and looked down toward the gate, still there, still padlocked, still bearing Judith's signature, glinting in the distance like something she thought was a weapon. She had built a permanent structure, posts set in concrete, chain, padlock, on a parcel I owned outright. I felt something settle in my chest. Not triumph. Not anger. Something quieter than both of those. The particular stillness of a man who has just realized the game ended before it started, and the other player is still making her opening move. I went back inside, back to work. I let her keep the gate for 2 more weeks. Every day it stood there. The damages were building themselves. With the gate standing and no response from me beyond that first morning, Judith moved to consolidate her position. She called a special HOA meeting for the 3rd week of August, sent notices to all 48 households, framed it as a community update. What it actually was, and Hugh Tanner told me this afterward, because he attended every meeting regardless of who called them, was a victory lap. She stood at the front of the Cedarbrook Heights community room with a printed presentation and told the assembled residents that the board had taken decisive action to protect the neighborhood from unauthorized commercial vehicle encroachment, that the access road issue was resolved, that the HOA had demonstrated it would enforce its governing documents firmly and without hesitation. She used the word professional 4 times in 20 minutes. 19 of 48 households showed up. Several left before she finished, because not everyone in that room was with her. And the ones who were not were getting louder. Nate and Jess Vorden had bought their house on Ridgeline Court 2 years earlier, specifically because of the vineyard. They had told their realtor they wanted to live somewhere that felt like the actual Willamette Valley, not a subdivision that happened to be near it. Jess had grown up on a farm in eastern Oregon. She knew what working land looked like, and she knew what it required. She raised her hand at that meeting and asked Judith directly whether the board had obtained a legal opinion before installing the gate. Judith said yes. She had not. She had asked her nephew, a first-year paralegal student at a community college in Phoenix, to read the CC&Rs over a weekend and give her his thoughts. He had told her the amendment looked valid to him. That was the entirety of her legal review. Hugh Tanner raised a different question. He asked whether anyone on the board had verified the ownership status of the land the gate was sitting on before the contractor poured the concrete. Judith said the road was clearly within the community corridor as defined by the amendment. Hugh did not push it further. He sat back down, folded his hands, and said nothing else for the rest of the meeting. I know that look. I have seen it in courtrooms. It is the look of a person who already knows the answer and is simply waiting for events to catch up. Meanwhile, Judith had begun using HOA general funds, the monthly dues collected from all 48 households, to pay for what she was calling a legal consultation. The attorney she retained primarily handled residential real estate closings. He produced a memo that neither endorsed nor condemned her position, filled with careful qualifications and conditional language. Judith read only the parts that seemed to support what she had already done and presented them to the board as confirmation. She posted in the neighborhood Facebook group that week. The board has received legal support for our access road policy. The matter is resolved. I screenshot the post. I added it to the folder. 2 weeks before harvest, I found out about the second letter. Hendricks and Cole had forwarded me the first one, the letter to my distributor, and I had documented it and moved on. What I did not know until a Tuesday afternoon phone call was that Judith had sent a second letter. This one to Timber and Table, a Portland-based restaurant group that operated 4 farm-to-table locations across Oregon and accounted for roughly 15% of Harlan Ridge's annual case sales. 12 years of business. The kind of relationship you build slowly and carefully and do not take for granted. The letter was on HOA letterhead, Judith's signature at the bottom. It informed Timber and Table that Harlan Ridge Vineyard was currently operating under an active regulatory dispute with local authorities, and suggested the restaurant group may wish to consider the reputational implications of their continued association with the property during this period of uncertainty. There was no regulatory dispute. There had never been a regulatory dispute. Every complaint Judith had filed had been dismissed. Every agency she had contacted had closed the matter without finding a single violation. The winery's licenses were current. The operation was fully compliant. There was nothing, not one document, not one open case, not one pending review that could be accurately described as a regulatory dispute. What Judith had sent to my business partner was a lie. A deliberate, calculated, signed and dated lie on official HOA letterhead. Marcus Reed, the managing partner at Timber and Table, called me himself. He was confused more than alarmed. We had worked together long enough that he was not about to make a decision based on an unsolicited letter from a homeowners association. But he wanted to understand what was happening. I told him everything. Calmly, completely, in the same order it had occurred. The gate, the complaints, the dismissals, the first letter to Hendricks and Cole, and now this. I emailed him a package that afternoon, the 1958 deed, the Yamhill County parcel map with parcel 47C highlighted in red, the county planning dismissal, the OLCC closure letter, the DEQ inspector's report, a timeline of every complaint Judith had filed and every agency response, 12 pages of documentation that told a single clear story. There was no dispute. There was one person with a padlock and a letterhead and a willingness to use both against a vineyard that had been operating on this land for 65 years. Marcus read it the same evening. Called me back at 9 o'clock. "We are not going anywhere," he said. "And Wade, can we come out during harvest? We would love to do a feature." I told him yes. I set the phone down and sat for a moment in the quiet of the farmhouse kitchen. Outside, the vineyard was dark, the vines just visible as rows of shadow in the moonlight. 4 weeks of work had gone into that fruit, 65 years of family history behind it. And one woman with a letterhead had tried to take a piece of it by making phone calls and writing letters to people who trusted me. I opened my laptop and started building the filing. By that point, I had accumulated the following. A trespass claim, the gate and its concrete posts sitting on parcel 47C without permission, without a permit, without impede, without any legal authority whatsoever. A private nuisance claim, the systematic interference with my lawful use of my own property over a period of 14 months. Tortious interference with business relations, 2 letters to 2 separate business partners containing false statements of fact about the regulatory status of my operation. Both signed, both dated, both on record. Abuse of process, a pattern of frivolous regulatory complaints filed across multiple agencies with no factual basis, each one requiring my time and documentation to respond to. And potentially defamation, the Facebook post claiming the matter was legally resolved in the HOA's favor. The letters implying an active regulatory dispute that did not exist. I called my litigation attorney friend in Eugene that night. Not to hire her, I intended to file this myself, but to have her review the complaint drafts with a fresh set of eyes. She called me back the following morning. "This is one of the cleanest Trespass Plus packages I have seen in 15 years, she said. "The only question is how far you want to take it." "All of it," I told her. I filed the following morning at 9:47. An emergency temporary restraining order requiring immediate removal of the gate from Parcel 47C. A complaint for trespass, private nuisance, and tortious interference with business relations. A declaratory judgment action to void the 2023 Community Access Amendment. And a notice of lien on the HOA's common areas as security for anticipated damages, a procedural move that would turn out to have consequences nobody in Cedarbrook Heights had seen coming. By 2 in the afternoon, the court had reviewed the TRO application. By 4:15, the TR was granted. By 5 of the clock, a Yamhill County Sheriff's deputy was standing at the gate with a copy of the order in his hand. I watched from the top of the driveway. "Madam," the deputy's voice carried in the evening air, "I have a circuit court order requiring removal of this structure from the referenced parcel. You have until 8 of the clock tomorrow morning." Judith was already there when he arrived. She had been watching the road, I think. Waiting. "This is wrong," she said. Her voice had lost the measured quality it had on the morning she would stood beside the gate with her phone raised. Our attorney said, "Madam," the deputy said again, quietly but without any flexibility in it at all. "The order is from a circuit court judge. If the structure is not removed by 8 a.m., I come back with a removal crew and the costs are added to the damages." She removed the gate herself that night. My doorbell camera caught it at 11:47. Judith and a contractor she would called on short notice, working by flashlight, unbolting the posts from the concrete bases she would have poured 3 weeks earlier. I was in the kitchen when the notification came through. I poured a glass of the 2021 Pinot Noir, a good vintage, deep and quiet, and watched the footage on my phone. The gate was gone by midnight, but the lawsuit was still running, and I had not played the most important card yet. The preliminary injunction hearing was scheduled 3 days after the gate came down. Yamhill County Circuit Court, McMinnville. A Tuesday morning in early September, the kind of clear, cool day the valley gets just before the season turns. I drove down from the Vineyard at 7, parked on 3rd Street, walked to the courthouse with my exhibit packet under my arm. 47 pages. Every document in the correct order, tabbed, indexed, with a table of contents on the front page the way Emile would have wanted it, everything in its place, nothing missing, nothing left to chance. Judith arrived with an attorney. I had expected that. What I had not expected was how unprepared he appeared, a solo practitioner who primarily handled residential closings, the same one who had produced the non-committal memo she would present it to the board as legal validation. He had clearly not had enough time with the file. He was carrying a manila folder and a yellow legal pad with handwritten notes. He looked like a man who had agreed to take a case and was now standing in a courtroom wishing he had not. I appeared pro se, representing myself, my legal right, and a calculated decision. I wanted to stand at that podium as Wade Harlan, vineyard owner, third-generation winemaker, the man whose grandfather had recorded that deed in 1958, not as an attorney in a suit making procedural arguments. I wanted the judge to see the farmer. The HOA's attorney led with adverse possession. It was the only argument available to him, and it was a weak one. He claimed the road strip had been effectively absorbed into the HOA's road network through continuous residential use over 19 years, and that the HOA had therefore acquired a legitimate interest in managing it. I waited until he finished. Then I stood up and gave him 3 minutes. "Your Honor, adverse possession in Oregon requires 5 elements under ORS 105-620: tactual possession, open and notorious use, hostile claim, continuous occupation, and payment of property taxes for the statutory period. The defendant cannot satisfy the 5th element. Parcel 47C has been tax assessed under Harlan Ridge Vineyard LLC's ownership continuously since 1958. I have 65 years of tax receipts in Exhibit F. The HOA has never paid taxes on this parcel, never filed a competing tax assessment, never recorded any instrument claiming ownership. There is no adverse possession claim here. There is a trespass." The judge looked at the HOA's attorney. "Counsel, do you have a response to ORS 105-620? A pause. The yellow legal pad. A long moment. "We would need additional time to review the statute, Your Honor." The judge's expression did not change. "The preliminary injunction is granted. The HOA and its officers are enjoined from erecting any structure, barrier, or obstruction on Parcel 47C or on the recorded access easement without prior court approval. The remaining claims will be heard in 60 days. He set down his pen and looked at the room over his glasses. I will note for the record that the plaintiff's documentation in this matter is unusually thorough. I would encourage the defense to retain counsel with experience in property easements before the next hearing. Judith was sitting in the gallery behind her attorney. She was staring at the table in front of her. I gathered my exhibit packet, thanked the clerk, and walked out of the courthouse into the September morning. Harvest started in 4 days. The road was clear. I stood on the courthouse steps for a moment and breathed. Harvest at Harlan Ridge starts before sunrise. Rosa Infante has run the picking crews for 22 years, and she operates on a schedule that does not bend for weather, equipment problems, or homeowners association presidents. 5:15 in the morning. The crew assembles at the equipment shed. Bins checked. Picking knives distributed. Rows assigned. By 5:30 the first team is in the Pinot Noir blocks, moving through the vines in the gray pre-dawn quiet. The only sounds the soft snap of clusters releasing, and the low murmur of people who have done this work long enough that they do not need to talk much to coordinate. I walked the south block that first morning with a coffee in my hand, and Emil's vines around me, and felt something I had not felt since August. Stillness. The particular piece of a problem that has been solved in a season that is finally allowed to proceed. The trucks rolled. The bins filled. The forklift moved crates to the refrigerated transport at the western gate, the real gate, the Vineyard gate, the one that had always been there, and by 9 in the morning the first load was on its way to the crush pad. Timber and Table sent a photographer and a writer on the 3rd day of harvest. Marcus Reed came himself, which I had not expected. He walked the south block with me in the early light, asked questions, tasted fruit straight off the vine the way people do when they want to understand what they are selling. The writer took notes. The photographer moved quietly through the rows without disturbing the crew. The story ran in Portland Monthly 6 weeks later. They titled it, "The Winemaker Who Went to Court to Save His Harvest." I had not pitched it. Marcus had not pitched it. Marcus had not pitched it. The writer had pulled the court records, public documents, all of them, and built the story herself. 2,000 words. A photograph of the south block at dawn. The old Emil vines in the foreground, the Chehalem Mountains behind them. I did not read it until the morning it published. Rosa brought a printed copy to the equipment shed and left it on my workbench without saying anything. I read it standing up, still in my work boots, with the smell of new wine coming from the cellar behind me. The Willamette Valley Wine Association shared it that afternoon. A wine blog with 80,000 subscribers picked it up the following day. Local television in Portland ran a 90-second segment. Nothing national. Nothing that would make a person famous. Just enough that the story existed in the world outside Cedarbrook Heights. Inside Cedarbrook Heights, the effect was immediate. And it was not gentle. The lawsuit was still running when the harvest ended. The trespass claim, the tortious interference claims, the declaratory judgment action, all of it was moving through the court on the 60-day schedule the judge had set. I was in no hurry. Every day the case progressed was another day of documented record. Another page in the file. Another number on the damages calculation. During discovery, I requested all HOA documents related to their road infrastructure. Maintenance agreements, utility easements, insurance records, contractor invoices, the full picture of how Cedarbrook Heights managed its internal road network. The response came back in 3 bankers' boxes. I spent a Saturday going through them at the kitchen table with a legal pad and a highlighter. Most of it was routine mowing contracts, asphalt patch invoices, a dispute with a landscaping company from 2019 that had gone nowhere, standard HOA paper, the kind of administrative accumulation that builds up over 19 years of managing a planned community. And then in the 3rd box, near the bottom, I found the 2004 survey. The original survey commissioned by the Cedarbrook Heights developer before construction began. Stamped, signed, dated. I unfolded it carefully on the kitchen table and weighted the corners with coffee mugs. I looked at it for a long time. The HOA's main entry road, the primary access road serving all 48 homes in Cedarbrook Heights, the road every resident used every single day to enter and exit their neighborhood, crossed a corner of Parcel 47C, a small dogleg in the road's alignment, approximately 80 feet in length, where the developer's surveyor had made a placement error in 2004. The road as built ran 6 feet over the Parcel 47C boundary line. 6 feet. 80 feet long. A surveyor's error that had been poured in concrete and asphalt and driven over 40,000 times in 19 years without anyone noticing. Without a legal easement over that section, every resident of Cedarbrook Heights had been crossing my land every time they left their neighborhood. Every morning commute, every grocery run, every school pickup, every HOA board member driving to every meeting where they discussed what to do about the vineyard. All of it for 19 years, across 8 feet of parcel 47C, without my permission, without payment, without even knowing. I sat back in my chair and looked at the ceiling for a moment. Then I called my litigation attorney in Eugene. "I need you to look at something," I said. She drove up the following morning, spread the survey on the same kitchen table, measured the overlap with a scale rule she pulled from her bag, checked it against the county parcel map, checked it again. "Wade," she said finally, "do you understand what this means?" I told her I did. If I chose to exercise my rights to the letter, if I filed a separate trespass action covering the entry road encroachment and demanded the HOA remedy, they would have two options: litigate a case they could not win, or reroute the entry road. The reroute would require removing 3 mature oak trees, regrading a slope, and resurfacing approximately 300 feet of roadway. The engineering estimate my attorney requested came back at $340,000, more than 3 times the HOA's current annual operating reserve. Instead, I did something they never anticipated. I sent the HOA board a formal easement offer. The terms were straightforward. In exchange for a perpetual recorded easement over the 80-foot section their entry road crossed, which they had always needed without knowing it, I would receive 3 things: a perpetual recorded easement explicitly protecting my access road in full, HOA acknowledged and bulletproof, a lump sum payment of $22,000 representing 19 years of unpaid land use, and a monthly easement maintenance fee of $285, indexed to inflation, for as long as Cedarbrook Heights existed as a planned community. The HOA's new attorney, a second one more experienced, brought in emergency rates after the hearing, reviewed the situation, and delivered his verdict to the board in a closed session. "The survey error is documented," he told them. "The encroachment is documented. The plaintiff owns the parcel. You either negotiate or you reroute at a cost your reserve cannot absorb. I recommend you negotiate." The board voted 5-0 to accept. The agreement was executed and recorded at the Yamhill County Recorder's Office on October 14, 12 days after the last bin of the 2023 harvest had been processed. The first check arrived 10 days later, $285, made out to Harlan Ridge Vineyard LLC, signed by the HOA treasurer. The HOA seal printed in the upper left corner of the envelope. I held it for a moment before I opened it. Just the envelope. Just the weight of it in my hand. Then I went inside, found a frame in the hall closet, and hung it on the tasting room wall next to the Osei family's letter of apology. By harvest season, Judith's HOA was writing me a check every single month. Just like I said. I was not in the room when it happened. I want to be clear about that. I am not an HOA member. I was never invited to their meetings and never wanted to be. What happened inside Cedarbrook Heights in the weeks after the easement agreement was signed was a community reckoning that belonged entirely to them, their money, their votes, their neighborhood, their consequences. I learned the details afterward from Hugh Tanner, who attended every meeting and had the particular gift of describing events without editorializing. The special membership meeting was called by petition. 34 of 48 households signed it, the first time in the HOA's 19-year history that the membership had formally petitioned to remove a sitting officer. The meeting was scheduled for a Wednesday evening in late October, 2 weeks after the easement agreement was recorded. 41 of 48 households attended. Hugh told me later that when he walked into the community room that night and counted the chairs, he knew it was over for Judith before anyone said a word. He had never seen that room that full. He presented the accounting himself. Calm, factual, without commentary. $11,400 in HOA funds spent without a full membership vote, the gate contractor, the attorney's consultation fee, mailing costs, filing fees. $22,000 in lump sum settlement payment. $6,200 in legal fees for the settlement negotiation. $285 per month in perpetual easement fees, indexed to inflation. Total direct cost of Judith Creel's 14-month campaign against Harlan Ridge Vineyard, approximately $39,600. Plus ongoing monthly obligations. The per-household share of the deficit, approximately $825 in special assessments, to be collected over the following 12 months. The room was very quiet when Hugh finished reading the numbers. Nate Vorden spoke first. His voice was even, but there was something hard underneath it. I moved here because I wanted to live next to a vineyard. I did not sign up to pay $825 because someone decided to declare war on it. Calvin Osei spoke next. Measured, deliberate. The way a man speaks when he wants every word to land correctly. This was done in our name, without our vote, without our knowledge. That is not how a community is supposed to work. Judith tried to respond. She had prepared something, notes on index cards, I was told, the way she always prepared for board presentations. She got through 2 sentences about community protection and residential quality of life before the room shifted in a way that made continuing impossible. Hugh stopped her, gently, but without any ambiguity. Judith, he said, you built a gate on a man's land. You did not check whose land it was. Everything that happened after that was the consequence of that one decision. The vote was 38-3 to remove Judith Creel as HOA president. The 3 votes in her favor were her immediate neighbors, the ones most vocal about harvest dust, the ones whose kitchen windows faced the access road. Everyone else voted to remove her. She left the meeting without speaking. Her car was gone from the driveway by the following weekend. A for sale sign appeared in her front yard 2 weeks later. The tortious interference claim, the letters to Hendricks and Cole and to Timber and Table, was settled separately. Judith's personal liability. The board refused to indemnify her for actions taken outside her board authority. She paid $14,000 from her own accounts, plus her personal legal fees of approximately $8,500. Total personal cost to Judith Creel, $22,500. The loss of her HOA presidency, and the home she had lived in for 14 months. She had accomplished one thing in all of that time and money and effort. A gate that stood for 72 hours. The lawsuit concluded in November with a full settlement agreement. Every claim resolved. The easement recorded. The monthly payments in place. The declaratory judgment voiding the 2023 Community Access Amendment entered by the court as a consent order permanent, on the record, binding on every future HOA board that would ever govern Cedarbrook Heights. I remember the afternoon the final documents came back from the county recorder. I was in the cellar, checking on the 2023 fermentation, the harvest that had almost not happened, now quietly becoming wine in the barrels the way it was always supposed to. Rosa Infante brought the confirmation email to me on her phone. I read it once, handed the phone back, and went back to what I was doing. She looked at me for a moment. That is it? That is it, I said. She shook her head and went back to work. That is Rosa. 22 years. And she still expects me to make more of things than they are. What I felt in that moment was not triumph. I want to be precise about that because triumph implies a contest. And what had happened here was never really a contest. It was a documentation problem dressed up as a conflict. Emile had solved it in 1958. I had simply been the one standing there when someone finally tried to test it. What I felt was something quieter. The particular relief of a weight you have been carrying for months finally setting down. The ability to breathe at a depth you had forgotten was available to you. I walked the access road that evening. All 340 feet of parcel 47C, gravel under my boots, the way it had always been, the way Emile had always intended. I stopped at the spot where the gate had stood. The concrete post holes were still faintly visible, already softening at the edges with the first November frosts. I took a photograph. Not for the lawsuit. Not for anyone else. Just for me. Hugh Tanner called me the first week of December. The new board, him as interim president, Patricia Sewell as secretary. 2 other residents who had never wanted any part of Judith's campaign had voted to invite me to speak at the December community meeting. Not to relitigate anything. Not for an apology, though Hugh said several members wanted to offer one. Just to talk. To let the neighborhood hear from the man whose land they had been living next to for 19 years, and whose name they had only ever encountered in complaint letters and court filings. I said yes. I drove down on a Thursday evening in early December. The community room held maybe 60 chairs. Most of them were filled. I stood at the front without notes. I had thought about what I wanted to say on the drive down and decided notes would make it feel like a deposition, and I talked for about 20 minutes. I talked about Emile. About County Cork and logging camps and volcanic soil and a deed recorded in 1958 by a man who understood that the piece of paper was the protection. About Frank, who expanded the vineyard and won the medals and died in the South Block on a Tuesday morning doing what he loved. About what harvest means to a family that has been doing it for 60 years, the weight of it, the specific smell of it, the way the whole year narrows to those 3 weeks in September when everything you have worked for either comes in or it does not. I did not mention Judith by name. There was no need. When I finished, the room was quiet for a moment. Then Hugh started clapping, and the rest of the room followed. Nate and Jess Vorden caught me by the door on my way out. Jess asked if they could bring their kids out during next year's harvest. Let them see how it worked. Let them understand what a working vineyard actually looked like from the inside. I told her I would have Rosa set aside a row for them to pick. Calvin and Adiz Uzose sent a card the following week. Handwritten. 2 paragraphs. It ended. Emile would be proud of how you handled this. So would Frank. I framed it. Hung it next to the first HOA check. Dave came home for Thanksgiving. She drove up from Davis on the Wednesday before, arriving just after dark with a trunk full of textbooks and a bottle of wine she had made herself, a student project, a small lot Pinot Noir from the university vineyard, her name on the label in her own handwriting. She set it on the kitchen table and looked at me with the particular expression she has had since she was 12 years old. The one that means she is waiting for an honest assessment and will not accept diplomacy. I opened it, poured 2 glasses, tasted it carefully. It is good, I told her. The tannins are a little grippy, but the fruit is honest. Another year in barrel and it would have been better. She nodded, satisfied. Poured herself more. We spent Thanksgiving the way we always do, just the 2 of us since Frank died, the farmhouse table set for 2, the vineyard quiet outside the windows. After dinner I took her to the South Block at dawn the following morning. The vines had dropped their leaves by then, the canes bare and gray in the early light, the old Emile root systems invisible beneath the soil, but present in the way they always are, deep, permanent, doing their slow winter work. I told her the whole story, beginning to end. The gate, the deed, the parcel map, the filing, the hearing, the survey error, the easement agreement, the check on the tasting room wall, all of it. She listened without interrupting. Maeve has always been a good listener, better than me at that age, better than Frank. She gets it from Emile, I think, though she never met him. When I finished, she was quiet for a moment, looking out over the bare vines. Then she said, "Why did not great-grandpa Emile just put up a fence in 1958? Then none of this would have happened." I laughed. I laughed longer than I had laughed in months. Standing in the South Block in the November cold with my daughter beside me and the old vines all around us. Because Emile did not think he needed a fence, I said when I could speak again. The deed was enough, and he was right. She smiled, looked back out at the vines. "He sounds like someone I would have liked." "He was," I said. "He really was." We stood there for a while without talking. The light was coming up slowly over the Chehalem Mountains, the kind of pale winter light that makes everything look clean and new. The vineyard was quiet. The access road was visible from where we stood, a thin line of gravel running along the western boundary, open and clear and exactly where Emile had put it 65 years ago. I understood something standing there that I had not been able to fully articulate before. The real thing Emile had built was not the road. It was not even the vineyard. It was the documentation, the habit of precision, the immigrant's understanding that in a country where you arrived with nothing, the piece of paper was everything. Emile could not build a fence around all of it, but he could record a deed. He could pay a lawyer. He could keep every receipt in a fireproof box under the farmhouse stairs and trust that the paper would hold when the moment came. It had held for 65 years. It had held through developers and subdivisions and HOA boards and one retired HR director with a padlock and a phone and absolute certainty that she was right. The deed was enough. It always had been. I want to tell you something before I go. Judith Creel did not lose because I was smarter than her. She did not lose because I had more resources or better connections or a louder voice. She lost because she built a gate on a piece of land without checking whose name was on the deed. That is it. That is the whole thing. 14 months of complaints and letters and county filings and attorney consultations and neighborhood meetings and Facebook posts. All of it, every single move she made, collapsed the moment a circuit court judge looked at Exhibit F and saw 65 years of consecutive property tax receipts with one family's name on every single page. She had a title, HOA president. She had a phone. She had certainty, the particular, unshakable certainty of a person who has never been seriously wrong about anything and cannot conceive of the possibility that she might be now. What she did not have was a deed. My grandfather Emil Harlan arrived in Oregon from County Cork, Ireland with $30 and a suitcase. He did not speak the language fluently. He did not know anyone. He had no family here, no connections, no safety net of any kind. But he hired a lawyer for every transaction he ever made. He kept every receipt. He recorded every document. He paid taxes on every parcel he owned, every year, without exception, not because anyone was watching, but because he understood that the paper was the protection, and the protection was everything. His grandson, a man who spent 11 years practicing property law, nearly lost a harvest because someone was willing to act before checking the facts. Emil's paperwork saved this vineyard 65 years after Emil filed it. If you own property, anywhere, I want you to do one thing after you finish watching this. Pull your deed. Read it. Find a property attorney and spend 2 hours with them understanding your boundaries, your easements, your parcel map. Know what you own. Know where your lines are. Know the number of every parcel on your tax assessment. Because the Judas of this world are counting on the fact that you do not. If you have ever had an HOA, a neighbor, or a board try to take something from you, a road, a view, a right, a harvest, drop it in the comments. I read everyone. And if this story meant something to you, share it with someone who needs to hear it. I am Wade Harlan. This is Harlan Ridge. And this is what happens when you plant your roots deep enough.